evidence is permissible in departmental proceedings, which I am carrying to assist your lordship. Notes will be giving the short notes for your lordship's notes, appreciation notes. Short notes. And what is the list of citations notes which the petitioner would be relying upon?
There are two sets of written arguments.
One for the other side. No, I have not signed both of them. आपका copy?
First is Usha Breakup.
Probabilities notes on the preponderance of probabilities notes. Paragraph notes, the concerned paragraphs are notes paragraph 33, 36, 38 and 39.
36.
Yes, 38 and 39. These are all not the issue of notes. Then notes, second case note is Haryana, paragraph 4. Preponderance of probability note, street rules of evidence doesn't apply. And note corroborative notes statements can be taken into account to understand whether there was a preponderance, whether it is a out and out notes false case or it is actually something has happened.
Strict rules of evidence is
Not required.
to proceedings before labor.
Then notes page 19 note instead of Haryana matter notes, paragraph 4. It is what it is well settled that in a domestic inquiry the strict and sophisticated rules of evidence under the Indian Evidence Act may not apply. All materials which are logically probative for a prudent mind are permissible. There is no allergy to hearsay evidence provided it has reasonable nexus and credibility. Then notes Cholan Norris is paragraph 15, 16 and 19.
Paragraph 16,
15, 16 and 19.
15, 16, 19.
Then Divisional Commissioner Lords,
This is also on the same point?
same point.
Preponderance of
Probabilities and rules of evidence and nature of notes, probative prudence which has to be seen. 2005 note is Divisional Commissioner, paragraph 8 to 11.
8 to 11. On the same point?
Same point. Then on the proportionality of punishment of the two note, see number 5 and 6 are on the issue of proportionality of punishment. This is the first MP Electricity Board is paragraph 17, and paragraph 1, 7, 8 and 9.
1, 7, 8 and 9. Next.
Ramanna Judgment Board is paragraph 6, 7.
6, 7. This is also on
Proportionality and 8 to 12.
next.
And
6,
then
7, 8,
6, 5, 6, 7 note is also on the same. Even 7th is that on the issue of whether even an assault note is a serious offence in case of a domestic proceeding.
The para would be? Serial number 7, para would be?
Para would be notes. What's the number of paragraphs? I've given
Okay,
it in my
anyways,
notes.
this is assault. This is all settled.
Settled notes.
Para.
Paragraph
Serial
notes,
number
which
6
is-
is para 6 and 7.
Yes, 6, 7 and 8 to 12. At least it is from 6 to 12, yes. I'm corrected, no, it's 6 to 12. And note in serial number 7 is 17 to 25, 26, number of paragraphs. We have given that in the written notes of arguments.
That's all.
That's
Let's say fairness of departmental inquiry was taken as a preliminary issue also. May kindly see annexure 4, page 46.
So they have given up that point.
Yes,
They have given up that point.
the witnesses does not support the case of the
They have given up that point.
Lordship.
See, well, once the inquiry is held to be improper,
Lordship.
it is open to the management provided they reserve the right to leak evidence. and prove the case against the workman.
Correct.
So they have led evidence, you have also led evidence. Now we have to see that what all evidences were led before the court to prove
Yes.
the case.
Lordship, may kindly see page 47, Lordship.
Page 47.
Of annexure 5. Jagannath Das का para 16.
Para number 16.
जी, क्रॉस एग्जामिनेशन लॉर्डशिप। मुझे याद नहीं है कि मेरा किस कान में स्टिच पड़ा था और खून का कपड़ा साफ पड़ने पर खून का लगा कपड़ा साफ हो गया। किस कान में इनको लगा इनको भी मालूम नहीं है कि दाहिने में लगा है कि बाएं में लगा है। देयरफॉर लॉर्डशिप चार्जेस
किस कान में स्टिच लगा था?
हाँ किस कान में उनको मालूम नहीं है।
स्टिच लगा।
हाँ इनको इनको मालूम नहीं है। And now lordship may kindly see the evidence of page 50 sorry 50 इसको छोड़ देते हैं इसको मेरे पेपर में गणेश राम deposition witness number 2
Page 50.
sorry 62 lordship para 6 may I read lordship
This is PW.
this is PW2
MW.
MW2 lordship
MW2.
Ganesh Ram
Page 60.
page 61 lordship
Page 61. Cross exam.
क्रॉस नहीं क्रॉस एग्जामिनेशन बाद में है एग्जामिनेशन इन चीफ लोग बोले हैं पारा 6 में देखा जाए
Page 60.
पेज 62 में जो
हाँ.
उस दिन की घटना में मैं नहीं देखा था एसपी सिंह मुझे बुलाया कहा कि जगन्नाथ दास को फर्स्ट एड में ले गया उसे चोट लगा है कैसे चोट लगी थी मैं नहीं था वहाँ लेकिन कान से थोड़ा खून निकल रहा था जगन्नाथ दास ने बताया कि रिलीफ के साथ घटना तथा गाली गलौज हुआ है मैं वहाँ गिर गया था चोट लगी थी बोल रहे हैं गिर गया था और उसे मोपेड गाड़ी में वहीं पर बैठा कर ले गए लॉर्डशिप में काइंडली सी क्रॉस एग्जामिनेशन लॉर्डशिप पारा 11 पेज 63 पर 10 m/1 को मैं क्या लिखा था मुझे मालूम नहीं है मुझे यह भी याद नहीं है कि जगन्नाथ दास को मुझसे कह रहा था कि आर्यन सिंह अपने आप को काबिल समझता है उसे घुसा देंगे धसा देंगे मेरा
So you want to say even on the touchstone of preponderance
Yes.
of probability, the order is sustainable.
yes page 66 lordship Ramanand Singh page 66
MW.
Ramanand Singh
Workman.
concerned workman
Ramanand Singh.
हाँ वर्कमैन जो है कंसर्न वर्कमैन पारा 3 पारा 3 यह है कि बाद में पता चले कि जगन्नाथ दास ने आर्यन सिंह को झूठा फंसा दिया है यह बात घरेलू जांच में भी पाया गया है
This is the Workman.
वर्कमैन and the issue number 1 lordship on the pleading of the parties following issue arises to determination dispute in between the parties these are given as below issue number 1, whether the termination of service of Sri R.N. Singh, crane operator, P number so and so, MS Tisco Limited, as made by the management is proper or justified. The findings is para 14, Lordship. Page 83, Lordship.
It has been read.
Yes, which is my favor, Lordship.
Certainly it is in your favor, that is why they have it.
Yes, but the witnesses does not support the case of the management, Lordship. This is my submission, Lordship.
For the learned counsel opinion on behalf of the parties, Dr. K.N. Singh. This petition has been filed challenging the award dated 25/1/2010 passed in reference case number 10 of 1998 by the Labour Code Jamshedpur, whereby the dismissal of the workman has been set aside and the workman has been directed to be reinstated in service with 50% back wages. And the direction has also been passed for payment of simple interest in case the award is not implemented within 60 days. The council, while the terms of reference are as under, the learned council submits that the concerned workman faced the domestic inquiry. The domestic inquiry was held to be improper, and ultimately the parties laid evidence before the Labour Court and entering the award has been passed. During the course of arguments, the learned counsel has submitted that he does not want to press his grievance in connection with the finding of the learned Labour Court that the domestic inquiry was held to be improper. However, by assailing the impugned award, the learned counsel has submitted that the manner in which the award, the material, the evidences have been appreciated is not in consonance with the concept of preponderance of the parties. He has submitted that the victim of the case, the victim of the incident, had fully supported the case and the management witnesses, and amongst the management witnesses, one of the witnesses was hearsay in as much as he did not see the incident himself, but he had interacted with the victim immediately after the incident and he was involved in taking the victim to the hospital. He has also fully supported the case of the management. The learned counsel has submitted that the learned court has also considered the point of.
May I know, sir?
Yes.
Just not, I'm sorry not for interruptions. Page note 45 notes. Person got the page.
Yes.
Notes page 45 last paragraph notes, paragraph 7. मारपीट का घटना कारखाना के अंदर टेंजिल एरिया में हुआ था। ट्रीटमेंट के दौरान दाएं कान के ऊपर स्टिच हुआ। It says but later on, but I don't know.
The learned counsel has also.
But no FIR was lodged.
The learned counsel has also referred to the evidence of the victim who has supported the case and has stated before the court that the incident had taken place inside the premises of the industrial unit, and he suffered stitches on the right ear. The learned counsel has also submitted that the learned court, though having held, after having held that the management failed to prove the case against the concerned workman, while deciding other issues, has also touched upon the proportionality of the punishment imposed by the management, and has held that the punishment imposed was disproportionate and excessive. The learned counsel has submitted that the matter arises out of fight between two persons inside the factory premises, in which one of the persons was injured, and there is an allegation that he was assaulted with a riding rod. The learned court has drawn adverse inference on account of non-production of the rod before the court. The learned counsel has submitted that the entire approach of the learned court was erroneous, and therefore it calls for interference in the jurisdiction. Yes, with respect to the manner in which the evidences are to be appreciated by labour court, the learned counsel has relied upon the following judgments: bracket 2008, bracket rules 5, SCC 554, party का नाम देते जाएंगे, ठीक है? 33, 36, 38 and 39. Bracket 1977, bracket rules 2, SCC 491, para 4. Bracket 2005, bracket rules 3, SCC 241, para 15, 16 and 19. And then bracket 2005, bracket rules 3, SCC 254, para 8 to 11. And has submitted that essentially the evidences are to be appreciated in line with the principles of preponderance of probability. Strict rules of evidence is not applicable, and hearsay evidence can also be relied upon if otherwise it is reliable. With respect to proportionality of punishment, he has referred to the judgment reported in bracket 2005, bracket rules 3, SCC 401, para 1, 7, 8 and 9. And bracket 2005, bracket rule 7, SCC 338, para 6 to 12. He has further submitted that assault in the workplace is sufficient to sustain the order of dismissal. For this proposition, he has relied upon judgment reported in bracket 2006, bracket 1, SCC 430, para 17 to 86. The learned counsel, appearing on behalf of the respondent, on the other hand, while opposing the prayer, has referred to the evidence of the victim who was examined as MW1 and has submitted that the victim did not, in his cross-examination, could not disclose as to in which year he suffered injury. He suffered, there was stitch. He has further referred to case of NW2. Page number what's it?
62,
At page number 62,
para 6.
para 6. To submit that, NW2 has himself stated that he had not seen the incident. And so far as the victim is concerned, he did not disclose as to how he got hurt. यही है ना?
जी.
But he simply stated that there was some bleeding from his ears.
Para 11 of the cross examination.
He has also referred to paragraph 11 of the cross-examination of NW2 to submit that he is the person who is said to have written the complaint, but during his cross-examination he has stated that he did not remember as to what he wrote in the complaint, right?
That is exhibit M by 1.
That was exhibit M by
M
1.
by 1. Yes.
The learned counsel has also referred to the evidence of the Workman at page 66, who stated in paragraph 3 that he came to know later on that he has been wrongly made, that the allegation against him was incorrect. The learned counsel has also submitted that the learned labour court has considered the materials on record in right perspectives, and there is no illegality or perversity in the impugned award calling for any interference. The charge was not proved, and therefore the impugned award does not call for any interference. He has also submitted that arising out of the incident, no criminal case was instituted. That's it?
No.
Arguments concluded. Post for judgment. The judge of the case. January last week we did Tuesday.
Get the notes.
Also case from supplementary list item 2 WPC 3857 of 2021.
Counter supplementary counter ready, but till later.
What is there in supplementary contract?
जांच रिपोर्ट हुई थी और उनको सस्पेंड भी कर दिया गया था. Thereafter
डॉक्यूमेंट्स लगाए हैं?
हाँ
सारे आपको मिलते हैं?
हाँ,
You want to respond?
अभी कॉन्टैक्ट किए पार्टी से तो बोला कि अभी मिल रहा है.
WPC number
Advance has been reduced.
3571, supplementary counter affidavit. The counsel for the state submits that in terms of order dated 19/11/2024, supplementary counter affidavit is ready for filing and he has tendered during the court proceedings, which is taken on record. Counsel for the petitioner pays for time. कब चाहिए आपको?
टाइम है इसको रजिस्ट दिवस है रजिस्ट अब कोई दिवस नहीं है.
The learned counsel for the petitioner submits that the grievance of the petitioner has been redressed. क्या हो गया? Inquiry complete हो गया?
अब मिल रहा है नहीं उनको मिल रहा है जो इसके लिए फाइल किया गया था कि जो खाद्य पदार्थ नहीं मिल रहा है इनके अगेंस्ट में एक्शन लिया जाए. उसको सस्पेंड किया गया. सस्पेंड के बाद फिर जब रिवोक हुआ आफ्टर 6 months दे आर गिवन.
He has also submitted that the petitioner is getting the required rationally, as per law, and he has no surviving rights. Correct? And therefore, he does not want to press the litigation. Consequently, the litigation is dismissed as not simultaneously.
Disposed of.
Dispose of it.
Insufficient
हो गया ना?
disposed of.
अब प्रेस ही नहीं करना, आपका ग्रीवेंस रिजेस्ट हो गया, बात खत्म हो गई. एलिगेशन बहुत सीरियस लगा है, इसीलिए सब लिखना है.
नहीं तो एलिगेशन तो है ही, लेकिन अब दे रहे हैं
आपको कोई ग्रीवेंस ही नहीं है तो बात खत्म है.
सस्पेंशन
आपको क्या ग्रीवेंस?
सस्पेंशन के बाद अब देना स्टार्ट कर दिए हैं.
बहुत अच्छी बात.
Sign कर लीजिए.
चलिए नेक्स्ट केस.
Passport case from Delhi list item 2, WPS 7063 of 2012.
How much time are you like?
To argue this matter 2-3 minutes, क्योंकि इसमें बहुत शॉर्ट चीज है. हम जो चैलेंज कर रहे हैं ना अमाउंट, दिस फिगर इज माय लॉर्ड्स 1,25,538 प्लस डिफरेंस ऑफ वेजेस 25,960. Total comes to 1,93,498. As per the order of this court passed in this case, I have already deposited the amount in the registry. It is lying there. Now the
Which
only
amount?
point,
Along with the compensation?
this is the total amount,
Total amount.
and it was directed when it was heard earlier that these are the cases of workmen you are fighting up to the High Court, and this. So we deposited. Now the only point is, which I took earlier also in the writ petition, I reiterate here subject to what my lords will say, that this respondent number 2 is the agency. He engaged all these workmen. Our case is that Central University, the petitioner herein, has paid as per the agreement. Whatever the agreement was entered into between this university and the respondent number 2, Cobra Security it is, we paid the entire amount to him. How much he has paid, deducted or not, it was the business of this respondent number 2, not ours. This is the stand taken. Secondly, even if it is accepted that this amount is payable to the workman, then how much this respondent number 2 has to pay, how much I have to pay, that is not there. These two aspects my lords may consider and dispose it of.
That being there, because the entire amount has to be, they are just your agency, and whatever arrangements you have made, that was being, whatever amount you paid as wages, that has been paid. But that amount was found to be less than the minimum wages. So consequently, there is a coextensive, your liability is there. So you have to pay, you have deposited this amount, we will direct that it should be paid to the, directly to the government. Why should the private respondent also pay this? आपको तो दे देंगे, वो सीधे उन्हीं के पास जाएगा.
Yes, we also
आपको
don't
तो
want.
नहीं चाहिए.
No, we don't want. They may directly pay to the workmen.
After,
यहीं से revenue
Yes,
होगा.
yes, my lord.
after proper identification, it should be paid to the.
Certainly,
Yes.
it has to be paid, and they will pay it as after proper identification होगा. यही amount है आपका 193
Yes.
और तो कुछ नहीं.
नहीं.
498, 193, 498.
Third, the learned counsel is hearing on behalf of the parties. This petition has been filed for the following reading. The learned counsel for the petitioner submits that there was an arrangement between the petitioner and the private respondent,
Number 2.
number 2, who was appointed as an agency for providing security services, and the petitioner has paid the entire amount to the agency as per the arrangement between them.
As per the terms of agreement between
As
the
per the
parties.
terms of agreement between them. And so far as the amount computed by the authority by virtue of the ensuing order is concerned, the entire amount has been deposited before this court. He submits that it has to be determined as to how much the petitioner may have to pay and how much the private agency is required. The learned counsel appearing on behalf of the private agency has submitted that the amount has been paid to the concerned security personnel as per the agreement, and it appears that the amount so agreed upon was less than the minimum wages, and consequently the assessment has been made. The petitioner, being the principal employer, is liable to pay the amount, and private respondent has nothing to do with the amount. He has also submitted that the amount can be directly remitted to the authority by this court, and certainly the amount would be paid to the concerned security personnel upon due. किसके पास remit होगा? After hearing the learned counsel's appearing on behalf of the parties and considering the facts and circumstances of this case, it appears that some arrangement was made between the petitioner and the respondent number 2 for providing security services, and a number of personnel were engaged. It is not in dispute that whatever was the arrangement between the petitioner and the private person, the same has already been paid to the private person, but during inquiry it was found that the amount which was payable to the private personnel to the concerned security personnel was not meeting the requirement of the minimum wages. Consequently, by the ensuing order, the liability has been fastened upon the petitioner, being the principal employer.
The authority would be Regional Labour Commissioner into bracket Central Ranchi.
This court, after going through the ensuing order, finds no illegality or perversity, and the quantum and the manner of assessment is also not in dispute. The petitioner, being the principal employer, cannot deny its liability. Accordingly, the ensuing order does not call for any interference. So far as the amount is concerned, the same has already been deposited before this court, being an amount of ₹1,93,498 as submitted by the counsel for the petitioner. The amount is to be remitted to
Regional Labour Commissioner
Regional Labour Commissioner
into bracket Central
within bracket Central
Ranchi.
Ranchi. इनका बैंक अकाउंट आप दे देंगे? The learned counsel appearing on behalf of Union of India, Mr. Ravi Prakash, has provided the bank account details, including IFSC number, वो भी देख लेंगे IFSC number of the aforesaid authority, which is as under. The learned registrar general is directed to remit the entire amount. ये 2,50,000 है. आप जमा किए 2,50,000. 447. वो होगा क्वांटम सब मिलाकर होगा. आगे कुछ होगा अमाउंट. You have deposited 2,50,000. 447.
ठीक.
FDR in the shape of FDR जमा किया.
जो भी कोर्ट का हुजूर का डायरेक्शन था.
हाँ, यहाँ तो ऐसे नहीं ना जमा हुआ है. इसको कैसे होगा? इनके पास कैसे जमा होगा?
My lord, may I? In the order, operating portion of the order, the mechanism has been given, my lord. So they may withdraw the amount from their FDR and they deposit the demand draft as per the direction of this of the regional level commission. Page 38.
लेकिन ये अमाउंट कैसे आया यहाँ पर 2,50,000 तो अमाउंट का मिसमैच ऐसे थोड़ा सा चेंज करना पड़ेगा ठीक है the amount has been deposited before this court by way of FDR in shape of short term deposits
2 lakhs.
it stands in the
जमा किया है उतना है 1
ये
लाख
मेच्योरिटी अमाउंट है वो
Yes.
हाँ
FDR.
क्योंकि हम जमा किए ना 1,93,498.
नहीं वो मेच्योरिटी अमाउंट
Yes.
अमाउंट आप जमा किए हैं
193,498.
193,490
Yes.
you received from Jharkhand High Court
झारखंड हाईकोर्ट में जमा किया.
देखिए सर दिखाइए हमको इसका क्या मोडालिटी होगा समझिए आप हाई कोर्ट में कैसे जमा किए थे एफडीआर बना के जमा किए थे
कोर्ट का डायरेक्शन था कि वहाँ कर दीजिए आप जमा.
लॉजिकल है ना ऐसे तो पैसा कहाँ से कहाँ जाएगा The amount deposited by the petitioner by the orders of this court is directed to be returned back to the petitioner with accrued interest thereon. Right? And the petitioner is directed to deposit the amount in the account of the after the account.
ये कोर्ट का यूनिक डायरेक्शन था कि यू डिपॉजिट विद रजिस्ट्रार जनरल एंड रजिस्ट्रार जनरल विल कीप इट इन द एफडीआर. दिस वाज द
FDR तो मेच्योरिटी के साथ ही ना आपको
हाँ
पैसा मिलेगा.
हाँ
And the petitioner is directed to discharge the entire liability. या ये FDR amount इनको डायरेक्टली भेज देते हैं
दे दीजिए ना, वो कोई दिक्कत नहीं. रीजनल डिप्टी कमिश्नर जो अथॉरिटी है रीजनल
the FDR amount with its maturity value be remitted directly to the
रीजनल
regional
लेवल
level commissioner
Central
central branch
he shall identify and pay it after proper
he
indemnity.
is directed to identify the concerned workman, concerned security guard and debit the amount to them. That's it.
Then the account number is
आप देखिए यहीं से चला जाएगा.
Dispose of.
If there is any, if the maturity amount is in excess of any liability arising out of the impugned order, the
That-
differential be refunded back
To the petitioner.
क्योंकि maturity amount हो गया
Yes.
251.
Yes.
That is also for 1 year मिला only 2021 अभी तो और ज़्यादा हो गया.
हाँ और ज़्यादा हो गया
हाँ.
होगा ना रिन्यू नहीं हुआ होगा ना
Renew नहीं.
रिन्यूअल का पेयर भी नहीं किया होगा और कोर्ट को भी नहीं ध्यान रहा होगा
Dispose of.
Passport case from daily list item 8, WPC 4123 of 2008.
The counsel will not for the private respondent.
But, what had happened, this matter was dismissed for default. Then afterwards, my client has taken the file.
we just wanted to know from you what happened in the case
Whereas that is still pending, Maharaj. Whereas we have received one document, the last order dated 10/3/2009, Maharaj. On that date, Maharaj, the issue of maintainability has been decided, Maharaj. That it is maintainable since Maharaj, the petitioner has only purchased 6.05 decimal of land,
still
Maharaj.
pending what should you do to so far as private respondent is concerned
Let notice be issued. Otherwise, if my lord
at the
permits,
stage of restoration also no notice
no.
was issued.
Or what I can do if my lord, I can assist your lordship. Just I need a copy of the brief.
I will give him the copy.
Let it be next week. I'll assist your lordship.
There is a subsequent order also, but the matter, what I was of the view is you assist next week. But at interlocutory stages they have come, as informed the matter is still pending. Whatever objection, even a res judicata is a matter of mixed question of fact
Yes.
and law. It is not a pure question of law, right? So these issues may be considered by the authorities since the matter is pending.
Yes.
Okay, 4123 of 2008. The learned counsel for the parties are present with the consent of the parties. Post this case for final dismissal on next Tuesday.
Let me in January, if my lord.
Next Tuesday.
Last.
अभी ऑर्डर कर सकते हैं
No, no.
अगला ट्यूसडे
Passport case item 9, WPL 5120 of 2008.
इसका केस है IUCS
Your Worship, even if we want to pay them, the problem is that we do not have any contact. So if the paper publication is made and eventually there is a settlement or they appear, we can at least come to a conclusion in that forum, Your Worship, and pay the amount. So paper publication may be made in this matter. Respond number 1 and 3, Your Worship.
no those people are not party
For Your Worship, but since sir, my senior had also submitted before the school that because the impugned order was of that nature, that is the reason we had made this. Invariably and others was not included, Your Worship, but the defect was also never pointed out.
you make the write the notice just 4 persons
Yes, Your Worship. I will file an IA.
you don't need to file an IA you don't have the details
It is there in the impugned order.
basic details are not there it is
Not
only the name of the one
Then the secretary of the union, Your Worship. Because they will have knowledge about the workmen that they were representing.
who is for respond number 1
Respond number 1 and 3 both have. Respond number 1, the communication that was received by his son was that he has died. Therefore, the secretary of the labor union is an important.
WPL number 5120 of 2008 Counsel for the petitioner waits for time to file an indemnity application in this case to include the concerned workmen whose minimum wages are involved in the business. The notice upon respondent number 3 has returned unserved on account of change of place. Respondent number 1 has already expired. As recorded in order dated 6/2020. The council should also ascertain the presence of the business of this application. Name will final paper publication will be announced. The deed will be done by 3rd of January. Post 3rd January के बाद में 5th, 6th, 5th would be a Sunday I suppose. On 8th of January.
Passport case item 19.
अभी पास ओवर नहीं होगा. We are in the midst of a matter of a child. आप लोग तैयार हैं ना दोनों से? Right, you are ready? पास ओवर के कितना टाइम लगेगा?
It will take time.
What is it?
Order passed under section 26(2) of the Shops and
That will
Establishment.
take time.
Yes.
Let it be any day in the month of January. Next week, my lord, there will be cats, so I will have some difficulties. Any date will fix.
आपका भी मैटर है.
Leadership, it was
आपके
fixed
केस
as
में काउंटर आया है.
leadership. Counter as you can leadership, we have also filed rejoinder. It was fixed as the first case at 215.
Just a moment, Mr. Rajiv, just give me 2 minutes. उनको सब कुछ छोड़ देते हैं फिर आपका
ठीक.
मिलान से आपका केस में टाइम लगेगा. You have filed your rejoinder. Where is the counsel for the other side?
Leadership, it was already leadership. This matters will also again take some time. It's a substantial question.
Yes, we will hear that. You have filed your supplementary or you have produced the documents?
Leadership, that has been filed. It was a direction of the court to produce the case, so that has been filed.
That has been filed
Leadership.
along with the rejoinder?
Leadership rejoinder has been filed way prior when the counter was filed.
You have filed it by way of
They are by way of supplementary affidavit.
No, we will not keep that matter pending for long. We will certainly fix a date prior.
Leadership can be taken up on Monday because on the 18th date, from the 18th onwards, leadership card is also functioning and I'm leaving on 19th. Can we kept for Monday?
We can do it परसों देखिए कितना हमको फाइनल डिस्कशन में.
Leadership supplementary calls to CA number 6.
6 or 4?
7135 of 2023.
4. Item 4 now.
Item 4.
Counsel for the petitioner says that he has filed the
Supplementary affidavit.
supplementary application, bringing on record
Constitution of the petitioner.
the constitution. Pose this case at the supplementary process. आपका मैटर कर देते हैं January. इनका serial number कौन सा?
19.
Yeah.
With the consent of the learned counsel, based on behalf of the parties, hold this case on 8th of January. प्राइवेट कौन गैस करेंगे? आप आर्ग्यू करेंगे इसमें?
No, that's Mr. Amitish Margasan. He's colleagues in another court. He's coming.
आएंगे तो हम लोग सुनेंगे, ज़्यादा नहीं सुनना है इसमें। आएंगे तो सुनेंगे, तब तक हमारा एक important matter है regarding claim. Ask him to be here once. The matter is coming up day after tomorrow, Mr. Amitish. They have filed a supplementary.
Friday, but I have some difficulty.
Can it be tomorrow?
Yes, tomorrow there is no
Then
difficulty.
tomorrow सुनेंगे?
नहीं, Friday assigned matters are being posted, मतलब therefore I have some difficulty.
नहीं, एक चीज ठीक है. Let us. I'm just thinking aloud. In a case where there is a trade union matter and there is some violation, right? The only punishment you can think of is cancellation of the.
There is no other rules does not provide for anything.
Therefore, even for a trivial thing, if it is found true, you will cancel it.
Yes, it is to be. I'll explain, madam.
No, you will explain, but we want to hear on this because it is not a matter of an individual person. This is the only forum through which they raise their grievances. So many persons are involved. There has to be some scale. See,
But we have to go by the rule itself.
certainly we have.
We cannot go beyond the rule, madam. Therefore, the question is here: the rule has not been, virus of the rule has not been challenged. Now, therefore, it is to be seen, Lord, in the light of the rule and the procedure which have been provided therein. This administrative decision has been taken, Lord. Therefore, it is to be seen whether the order can be said to be perverse without jurisdiction. These are the power of judicial review.
blacklisting वाला कुछ cases देखे थे ना?
Yes,
इसमें
my lord.
permanent blacklisting नहीं हो सकता.
The permanent,
That was by way of judicial.
my lord, the permanent blacklisting, my lord, so far as that part, I'll explain, my lord. I will explain the difference between blacklisting, so far as that withdrawal of the recognition is concerned. The object of both the things are different, my lord.
So just think.
Yes, I understood your lordship view, my
Because
lord.
it's a matter of so many people.
Yes, definitely, my
They
lord.
have an outlet through which
I'll
they raise
explain, my
their
lord. I'll explain, my lord. Here, under what circumstances it is to be seen. It is not as such that the fresh organization cannot be, fresh association cannot be made, my lord.
How
They,
will the fresh association become a successor in interest of this?
I am not saying successor, my lord. The question is, it is not a permanent body which is to be there itself. Once my lord, so far as the scope of this rule is concerned, my lord, that has been considered by the Supreme Court, my lord, and I'll refer to those paragraphs also, my lord. I'll explain, my lord.
You have those judgments.
Yes.
Where are those judgments?
I'll give, my lord.
दे दीजिए. आपके भी कुछ judgments.
Yes, ladyship.
Where
Yes,
are
I
those?
was.
Kindly provide it. सब तो पढ़ के आते हैं, हमको तो थोड़ा कमजोर है हम. थोड़ा पढ़ना पड़ता है. बिना पढ़े नहीं डिसाइड कर सकते.
हम भिजवा दे देंगे.
दे दीजिए आप लोग दोनों जी जजमेंट्स अपना दे दीजिए. I will read and come and then
Yes, ma'am.
make up our mind. I was just thinking about this. कि ऐसा नहीं हो सकता कि सीधा
My
capital
lord,
punishment
every
दे दिया
rules,
और काम
every
खत्म.
act and the rules, my lord,
Has
it
its
has
own
own
value.
object, my lord. It has its own object.
It has its.
Therefore, with keeping in mind, so far as the object of the rules is concerned, we have to explain, my lord, so far as the
When you
provision.
argue the case, keep this aspect of the matter in mind. This
Yes.
is what I am disclosing.
Lots of.
I want to hear both of you on this. आपने भी कुछ
Mark it.
research
Yes,
किया है इस
ladyship.
पर?
Leadership, there are other statutes as well. For example, there is the Maharashtra statute which governs recognition of trade unions. Therein also, leadership, the statute provides for a particular section wherein de-recognition can be there. The next section, leadership, is that of de-recognition. That states for a maximum period of 1 year only can a trade union be de-recognized, and it has the power to re-recognize itself.
We will see.
Yes, lady.
Because that is what
The
you know.
the
was
trade
happening
union,
in
the
my-
trade union is absolutely different concept.
see that.
Leadership.
Service associations
We will
fall
see
within
that.
the
Yes,
last.
yes.
We are concerned with this
Yes, ma'am.
aspect.
I'll explain you.
Judgment से जितना भी आप भी सारा
हम भिजवा दें.
कल ही सुनेंगे. उनका डेट कल तक. उनका क्लियरेंस रिकॉर्ड. रिस्पोंडेंट अपने क्लियरेंस मेमो को क्लियरेंस. Now that matter please.
From daily list item 21, WPC 1709 of 2019.
short notice of liability. Yes, please.
How did it begin? Just I had gone through the covering search into the entire file because it's a jumbled facts. So I just made search and found that what had happened, and that will be reflected from her own statement, which they have annexed along with the counter affidavit which they have filed. In the paragraph 310, she had stated that she was under stress. Kindly have a look. 26, 11, 24, 58 plus 5.
What is the date of birth of the child?
1st May 2018.
1, 5, 3. Age of the mother.
That was never disclosed. So the first time she says that going 2000 in the month of August. 23rd of August 2000.
23, 8, 2000. Days of birth.
21st. 21st. I'm sorry.
21st.
20.
So she was slightly less than 80 years.
It is. On 13/8, the order when CWC was passed, she was
Order was passed on
13/8.
8, 20.
With the rider, 2 months time was given to her to reflect in terms of section 35. Says that parent or the guardian shall be given 2 months time to reflect, come back and say as to whether they want to continue or do not want to continue. By that 2 months time, she had become miserable.
Just a moment. The order of NCWA is at page
CWC.
Sorry, order of CWC is page number?
Annex 6, page 97.
97.
Upon the undertaking which was given in page 96, these are all the statutory exercises. So before we proceed further, and why did I come to the court? That's also important. She says in the para 310 that she was under tremendous stress. May I read it? This further submitted that in addition to being minor, respondent number 6 was under tremendous stress by virtue of becoming an unwed mother. Tremendous anxiety of thinking such and such child's future for a short of while. She made it to her to part with the child.
This is you are reading affidavit dated?
Affidavit dated 26 November 2024.
26 November. So we are reading para number?
Para number 310 at page number 4. 3 Roman 10. That's good for further. That's further submitted that in addition of being a minor, respondent number 6 was under tremendous stress by virtue of becoming an unwed mother. Tremendous anxiety of thinking of her child's future forced her for a short while to part with her child, since she was not in a position to take proper decision. This is what she said. So this entire episode began with this reasoning. Now what happened that in the month of July, something happened, she took the child and something happened, then I informed the CWC, that is, that was led to lodging of an FIR. I raised a voice that this racket is going on. The FIR is at page number 77. It is on my statement. My statement, which was forwarded by CWC, the relevant portion begins, my statement comes at page 81. I informed the Child Welfare Committee as to what's going on. Till then, no hue and cry from any corner, but once I raised this point that this is the sort of racket going on, on that an FIR was lodged, and not only that, this MOC, this Missionary of Charity, was also sealed. The government has filed a counter affidavit. It was raided and its recognition was withdrawn. Registration was cancelled.
Let us see the FIR. Let's have a look at it. What happened to this FIR?
Upon that, the charge sheet has been submitted, the trial is going on. In the trial, she had given a deposition, and her deposition has been annexed by them in their counter affidavit, which I is referring.
You are an accused in the case.
No, I am not.
Not considered.
In the
What is
FIR,
not considered?
आप ऐसे साथ-साथ नहीं बोलिए, एकदम शांति से रहिए. Let's read the FIR.
I have not been charge sheeted. The trial is going on.
Can we read the FIR?
J.
Can we read the FIR? What was your grievance when you filed the FIR?
That she had taken the custody child.
You are reading page number 80.
81. 80 is the forwarding by the CWC. I wrote to the Child Welfare Committee that look at this type of things are happening, and that is what the statute also mandates.
Can you read this?
लंबा है, 2-3 पेज का है, पूरा पढ़ना पड़ेगा, पूरा कहानी, लंबा चौड़ा कहानी है. The sum and substance, he says that the child was given to him through the agencies, and then they asked him to come to Ranchi, and she took the child in her custody, and she was playing. They told that she'll be going to family court. Then they started ringing her. Then she very hesitantly appeared and said that I was there, and she was making so many excuses. So thereafter, the child was given to this MOC, the Missionary of Charities. Then I ultimately went to the Child Welfare Committee and said that this is sort of affair, and the Child Welfare Committee took the position and handed it over to me after making an inquiry.
So I just want to know from you, as per the provisions of Juvenile Justice Act, what is the procedure?
हाँ, तो प्रोसीजर हम कोई वहाँ पर तो माहिर है. ये हुआ, इसके बाद
Initially when you took the child, it was with Missionaries of Charities at Nirvan.
the roles of missionaries charities, section 66 में kindly be seen.
Juvenile Justice Act. Section 66.
Of the Juvenile Justice Care Protection and Children Act 2015.
Under which provision they are given some,
There is a provision that the state government shall recognize organizations which will be called specialized adoption agencies, and that's the statutory provision under section 65 and 66. 66 is those who are registered, and
66 is not registered. And 65 is specialized adoption.
No, please let us read it. 66 is about registered. All 65 is about recognized and registered. 66 is about registered. All the institutions registered under this act. I was MOC was registered, Missionary of Charity was registered, and registration was cancelled in the year 2019, probably in the month of January 2019. So on the relevant date, it was a registered organization. That is filed with the counter affidavit that on January, soon after my complaint, I made a complaint on 3rd of July, and thereafter the institution Missionary of Charity was raided. And thereafter the inquiry was conducted and found that the affairs were not okay. Shall I read section 66? Counter affidavit of respondent number 6 of 14/11/2000.
You just read the provision of law.
Yes.
Let us see what is the procedure of giving for adoption and
All,
where is the violation.
all the institutions registered under this act, which may not have been recognized as specialized adoption agencies, shall also ensure that all the orphans or abandoned or surrendered child under their care are reported, produced and declared legally free for adoption by the committee as per the provisions of section 38. And if it failed to do so, if it fails to do so, clause 3 में इनको 50,000 rupees का punishment हो जाए. Clause 3 में kindly see. If the specialized agency fails to do so, then let us go back to section 38.
Yes,
38(3). Notwithstanding anything contained in any other law, for the time being in force, a child of a mentally retarded parent or a unwanted child of a victim of sexual assault, such child may be declared free for adoption by the committee by following the procedures under the Act. Undoubtedly, it was a child with unwanted child, she herself says, and so then the procedure was to be adopted by the Child Welfare Committee for declaring it free for adoption.
so this procedure was not followed.
Section 31.
This was the procedure which was not followed.
No, this procedure was to certain extent followed because the committee passes an order which we had seen, I mean at page 96 or 97, where the committee says that in exercise the past they handed a child pending an inquiry, and that is what the law says. Let us see section 31, production before the committee. A child in need of care and production may be produced before the committee by any of the following. इसमें नंबर 3 को देखा जाएगा. Children service or any voluntary non-governmental organization or any agency as may be recognized by the state government. Any agency which is recognized by the state government may produce a child before the Child Welfare Committee. And if it is done, then the inquiry is to be made. Then 38(1). We are again back on 38(1), the procedure which will be to adopted. In case of orphan abandoned child, the committee shall make all the efforts such and such the parents, the guardians, such and such. First proviso जो है वो important है. Provided that such declaration shall be made within a period of 2 months from the date of production of child and who are up to 2 years of age. This is the inquiry is mandated to be done within a period fixed. Then we have to we may have a look at section 35. What is the procedure? Sort of एक लाइन से सीरियल ऑर्डर्स में है. After the child is produced, then what is to be done? Number 2, 35(2), if after the prescribed inquiry and counselling, the committee is satisfied that the surrender deed shall be executed by parents or guardian, maybe by the before the committee, the parent or the guardian who, number 3, the parent or the guardian who surrendered the child shall be given 2 months time to reconsider their decision. That is what page 97 के order में लिखा हुआ 2 months time, इसीलिए 2 months time दिया गया. And during that time, intervening period, the committee shall either allow after due inquiry or the child to be with the parents, guardian under the supervision or place the child under the specialized reduction agency, and if she is below 6 years of age, the child home if he is above 6. This is the 2 years procedure. उसके बाद क्या हुआ ये क्लियर नहीं. इसके बाद क्या हुआ कि जो स्पेशलाइज्ड एजेंसी जो थी क्या रेड हो गया उसी टाइम में 3rd of July व्हेन आई फाइल्ड एन एफआईआर, उसके तुरंत बाद रेड हुआ. उसके बाद उनका डॉक्यूमेंट सीज हो गया, सील में चला गया, रिकॉग्निशन उनका रजिस्ट्रेशन कैंसिल हो गया. तो 2019 में हुआ, लेकिन रेड उनका काइंडली देखा जाए उसको एनेक्चर में उसमें लिखा हुआ 13th of July को ही हो गया, 3 जुलाई को ही हो गया. कहाँ है वो? रिस्पॉन्ड नंबर 6 का काउंटर एफिडेविट है, उसका लगा हुआ 5 का. अच्छा 5, सॉरी, पेज नंबर 10, द एफिडेविट डेटेड 14/11/2019. है उसमें लिखा हुआ है कि इनके यहाँ कब छापा डाला गया. झारखंड राज्य पहला लाइन में ही लिखा हुआ है.
ठीक है, छापा हुआ
13/8 का ऑर्डर है. 12/8 को संचालित मिशनरी चैरिटी निर्मल हृदय बाल गृह पूर्वी जेल रोड का निरीक्षण किया. निरीक्षण के पश्चात ये पाया गया इसमें लिखा हुआ प्रोविजन ऑफ लॉ जो है गलत लिखा हुआ है, लेकिन सर हम कंसर्न नहीं है. पेज नंबर 10 पर है. मिला 12/8 को क्या, हाँ, निरीक्षण किया गया. निरीक्षण के बाद पाया गया कि झारखंड किशोर न्याय नियम 2017 के प्रावधानों, 2017 नहीं होना चाहिए, 2016 का रूल्स है, 17 में तो रेगुलेशन बना है, के प्रावधानों का अनुरूप नहीं किया जाता था. और जो 23/10/2008 पे शोकॉज हुआ, उसके बाद इनका कैंसिल कर दिया गया रजिस्ट्रेशन. जून, इसके नीचे में लिखा हुआ रांची जिले गठित संपत्ति द्वारा जून 2018 में भी इस संस्था का निरीक्षण किया गया. Anyway, the committee was to get the report from the agency which has handed over the child's custody. वो रिपोर्ट नहीं आ सका और चाइल्ड वेलफेयर कमेटी इसके बाद कुछ नहीं कर सकी. तो आई वॉज एप्रीहेंसिव कि यहाँ जो होने लगा मेरे एफआईआर करने के बाद फॉर द फर्स्ट टाइम लेडी का वो स्टेटमेंट आया कि हम साहब पैसा दे करके चाइल्ड लिए थे और वो पैसा रिटर्न करके लौटाना चाहती. उसका डेट भी 3rd of July ही, 3rd of July को ही एफआईआर हुआ, 3rd of July को ही उसका स्टेटमेंट दिया है.
मतलब which lady, the respondent? or the petitioner?
The respondent.
She gave a statement.
I-
ऐसा लेके child to here.
ये हमने जब दिया ना, उसके बाद ये स्टेटमेंट उसका आया कि हम पैसा लौटा के अपना बच्चा वापस लेना चाहते हैं 3 जुलाई को, क्योंकि हमने एफआईआर कर दिया था ये बच्चा को लेकर भाग रही है। तो उस टाइम में ये स्टेटमेंट 3 जुलाई को ही आया फॉर द फर्स्ट टाइम।
पैसा हम वापस करके हमको अपना बच्चा
हाँ, ये स्टेटमेंट उसके पहले तक कभी नहीं आया था। और ये स्टेटमेंट जो ये पेज 92 पर, इसके बाद जो एक क्वेरी था अभिजीत का, कुछ सेक्शंस और हम लोग रेफर करना चाहेंगे। थर्टी सिक्स थ्री 36 is the inquiry to be made by the child welfare. पढ़े? 36. After the completion of inquiry, the committee is of the opinion that the said child has no family or ostensible support, continued need of care and protection, and send the child to specialized adoption agency if the child is below 6 years, from a children home or to a fit facility or person till the suitable means of rehabilitation are found for the child as may be prescribed to, or till the child attains the age of 18 years. So the fit person और इज फिट और नॉट फिट पर्सन, उस पर इंक्वायरी हुई थी। ऑनरेबल कोर्ट ने मांगा था हमारा कैपेबिलिटी, फाइनेंशियल कैपेबिलिटी, वो हमने यहाँ प्रोड्यूस कर दिया है। और क्योंकि अब यहाँ पर मेजॉरिटी और माइनॉरिटी वाला जो बात आ रहा है, पता नहीं इसमें क्या होगा नहीं होगा, लेकिन सेक्शन 38 का 3 जो कहता है there is a non-obstant clause, notwithstanding anything contained in any other law for the time being in force, if it is a child of unwanted child, then it shall be declared free for adoption by the committee. And the non-obstante clause, what extent it can go, no, it doesn't say that notwithstanding anything contained in this act, but it says about any other law. Whether this 8 days which had which were short, and secondly, even after the 2 months time, after 2 months time, this 8 days gap also vanished. Then, if the order was wrong, section 101 appellate remedy was there, she could have availed of. Do not say, I mean, but this sort of things which came only after when I informed the authorities that look here, this type of thing is going on, whether I am being penalized for calling a spade a spade. Something, somewhere, I mean, if the larger thinking will be there, I mean, somebody goes to a court of law for raising the grievances that, look here, these are the state of affairs going on. I didn't hide anything, I said, I mean, what had happened prior to that. But everything was told before the committee. Committee made an inquiry, passed it. And if she was really grieved, she could have come to the court earlier, filing her own application instead of writing my own book. because I had made allegations against her, and in a retaliation, I have been made an accused. That is all.
Your Lordship, this is actually a classic case of some people, those of who got a lot of money, and in connivance with the authorities, depriving a poor Adivasi girl of her child. It was stated here that the petitioners had a grievance and they wrote the complaint to the CWC. What made them to make the complaint? Just because the biological mother demanded her child back. And on 3rd of July, when the biological mother, the petitioner, all were presented before the CWC, the child was with the biological mother. I may be permitted to read.
In order to give the child for adoption, what all steps were required to be followed and that was not followed?
Your Ladyship, first and foremost, the child should be an orphan, abandoned or surrendered child. In this case, it's not.
Orphan, abandoned.
Or surrendered child. Here the biological mother is claiming the child.
But biological mother herself had given the child.
Yes, Your Lordship, that's where I am coming. She was an unwed mother. Just imagine a minor getting a child pregnant and the society, what's going to happen to her? Then she was under tremendous stress at that moment. So for a short while she thought that what will happen to me and to my child if I take the child home? So in that, this one for a
She gave birth to the child where?
in the Southern Hospital on 1st of May 2018. And on 3rd, she was discharged from there.
When she was discharged,
3rd of May.
to Nirmal
Yes, she was taken to Nirmal Hriday. And on 16th,
on which date she was taken?
3rd of May.
3/5/2018 to Nirmal.
Yes. Then on 16th, she was discharged from Nirmal Hriday and handed over the biological mother, the child, to respondent number 6 mother.
On 16th, she was discharged
From Nirmal Hriday.
What is the date on which the petitioner was handed over the child? Exact date?
That we will not know because
She was discharged from Nirmal Hriday without the child?
with the child.
With the child.
Yes, yeah.
So what happened there?
Yes, 16th she was discharged from Nirmal Hriday, and let me make one submission that it was said that it's a specialized adoption agency. Nirmal Hriday is not a specialized adoption agency. They had the license for that one, but when 2015 when the new rules came, they decided that they are not going to be adoption agency. So after 2015, to my knowledge, it is no more. But then obviously the cancellation happened because they never applied for renewal of the registration. So they never, after
With the
2000,
influx of time and with the change of law, their license was not valid.
they did not renew the license.
That's right.
Because they realized that given the present condition, given the charism and the principles, they cannot get into, because single parents could adopt and son, which according to their only a full-fledged family can adopt and son. So because of the principle, they decided that
So she was discharged from Nirmal Hriday on 16/5/2018 with the child.
yes, to the mother, it was given to the biological mother's mother, Jyoti Topo,
Okay. With the child given to the
mother of the biological mother.
grandmother of the child.
Yes, yes, Your Lordship.
Then what happened?
Then that was the time that Anima Indua, King, Mother Devi, all those people, those who were in between. Because Anima Indua was the one who used to take these unwed mothers to Sadar Hospital. Because for any medical care, they were referred to Sadar Hospital. And Mother Devi was a part-time guard at Sadar Hospital, who was also working at the residence of Sandeep Gupta, who is a relative, close relative of petitioner number 2. in this. So through that, they came to know.
We will not go to that extent. On 16/5/2018, the child was released
From Nirmal
from
Hriday.
Nirmal Hriday. The mother, biological mother, was also released, and the child was with the grandmother of the child.
Yes.
Right?
So
With the grandmother. Okay. Then how did it pass on to the petition?
yeah. So through Anima Indubar, who actually played in between without the knowledge of Nirmal
We
Hriday.
are not talking
Okay.
about any third person.
Yes, yes.
Whether it was part
Then
of
it was given to the petitioners.
petitioners by the grandmother.
No, to the biological mother.
It was given to the petitioners
Yes.
by the biological mother.
Yes.
That date is.
And in Duar, in all probability, 16th itself.
We don't know, but biological mother was very much in picture when
Yes.
the child was given.
Yes, Your
What is
Worship.
the date?
16th.
On 16th only.
Yeah.
On 16/5/2018, the child was handed over.
And
then,
without following any, they have not informed the CWC. Petitioners never informed the CWC.
petitioners, they are only wanting the child. The procedure has to be followed by the institution, isn't it?
But institution is not.
But since the child was handed over outside the institution did not have a role to play for him. Okay. But even while handing over the child, the petitioners also did not play any role.
Yes. I mean, they just took the child and went
but
to
for the,
UP.
okay, for the procedure for adoption of child,
They did not.
they did not. Under
Then
all-
what happened, Your Lordship? That is more important. Then what happened? The biological mother immediately realized, because she's a mother, immediately realized that she cannot be away with the child. So she started to demand back the child. That's where all the problem happened. When she started to demand back,
When was her earliest demand made?
on record it is 1st of July. They bring the child to Ranchi. She has been contacting Anima because she is the one who contacted. Actually, she never had with the direct contact with the petitioners. So she started to say, "Humko to bacha chahiye." So then Anima told them a lie, because why should there are statements? Anima started to cry. If it's a legal procedure, why should you cry to get the child back? It's a very clean thing that you get the child. We will do all the formalities. But Anima started because she realized that the whole thing is getting out of control because biological mother is demanding the child back. So then they come here and they are I apologize. Then the petitioners come here. So they are not coming because of any social commitment or anything. Because the biological mother started to demand the child back, and then they realized that they are losing the child. Then they came to CWC. They never came before that. And the CWC, in collusion with the petitioners, I don't know what is the reason behind that. CWC, when in her statement, says that when she saw the biological mother with the child, she got shocked. How come the CWC gets shocked when child is with the biological mother? It is the most natural thing to happen. But then how come CWC gets shocked?
Prior to handing over the child to the petitioners, CWC was never known.
It looks like. Yeah. Awesome.
And after the child was brought by the petitioners, they went to CWC.
Yes, because the petitioners, when they realized that they are not getting the child back, then they went to CWC to lodge the complaint. Not any time
At
before.
what point of time did the biological mother took the child from the petitioners?
In all probability, 2nd of July, when they came
How
to.
and in what manner?
In all probability, Anima in Dubai took the child from the petitioner, saying that we have some formalities to complete in the family court.
And thereafter, when they went to CWC handed over the child to the petitioners.
In all probability, that's what it's most shocking.
This is how they got the child and they took away the child.
I apologize.
How the child is now in possession of it.
Okay. Then what happened was that then there was the whole thing got fizzled out of the hand. Then complaint was lodged. Then there was a criminal case was lodged, heinous sections act as series as 370 trafficking, and the petitioners are named in the this one as purchasing the child, allegedly purchasing the child. And on 13/8, CWC makes an order saying that the child should be handed over to the so-called the accused. They are accused actually of a heinous crime, and to them CWC is handing over the child.
That case has been registered as an FIR.
Yes, your leadership. That's the FIR. It's
That
there.
is the FIR.
Yes, and they are named there, and CID is still investigating the case, and it's not yet. And this is where we suspect high-handedness. Even when they approached the Honorable High Court for anticipated bail, the counsel appearing on behalf of CWC, on whose direction this case was registered, never even opposed the plea.
We are not.
No, I'm just saying the collusion. Otherwise, when the biological mother claims her child, what right CWC has got to snatch her child away from her? And there is a statement.
I've got a personal problem. 4 बजे के बाद हमको गाड़ी ड्राइव करके उतना दूर जाने में दिक्कत हो जाती है, तो I'll be seeking a leave because हमको पर्सनली ड्राइव करके उतना दूर जाना पड़ता है सवेरे।
तो आप ऐसा करिए, चाइल्ड को यहाँ प्रोड्यूस करिए और उसको यहाँ पे हम लोग चाइल्ड शेल्टर
प्रोड्यूस कर देंगे।
उसके बाद ही यहाँ पे ऑर्डर
जी, आदेश किया जाएगा।
चाइल्ड शुड बी प्रोड्यूस एंड देन वी विल सी।
जी, ठंड ज़्यादा पड़ रही है, जनवरी में कर देते हैं।
Just a moment, please hold on. Their prayer is to restrain the respondents from separating the male 15 days baby given in adoption to the petitioner on 15/5/2018.
So false.
It appears that on the day this petition was filed, the child was with the petitioners.
Yes, Your Lordship.
And they are just seeking a direction to restrain the respondents from
It was filed in
snatching
the
the
year.
child from them.
It was filed in the year 2019, pursuant to the order of the court, CWC. The custody was given in the month of August 2018.
Your Lordship,
Was
they
there,
are.
was there any direction issued by any authority to you to hand over the child back to the biological mother?
And also, Your Lordship, on 13th.
Nothing of that sort. And so far as she was also made an accused in that FIR, because I lodged an FIR, she was made an accused.
And there was petition also. And
Anyway,
also, Your Lordship, on 13th/8, that order is made.
बच्चे
It
को
is
produce
never.
कर देंगे, बच्चे को
I was
produce
never
कर
party
देंगे।
to. I never knew such an order, and it was never communicated to me. I was of the impression that the child is at the shelter home because CW snatched away from me the child.
2 महीने का टाइम दिया।
But then that order was never communicated to me. When the order was passed, I was not there. I was not there.
There was a direction to produce the child. There was a direction passed by this court to produce the child.
Yes, Your
Which is that
Lordship.
order? Which is that order?
है उस टाइम में चाइल्ड शायद आया था या क्या हुआ?
आया था लेकिन biological mother identified लेकिन तो उसको
Yes, Your
हाँ
Lordship.
हाँ, this is राजेश कुमार
Which is
जी।
that order?
नहीं बोल लोग वो सारा चीज तैयार कर रहे हैं। जान रहे हो हम इसके बीच में आए हैं, पूरा कहाँ से आइडिया है?
You see, on 4/10/2024, the child had come, but since the identity of the mother was not available, so we have postponed the case. Right? We produced the child, and we want that this case should be decided when the child is present.
Yes.
Would be better? जो होगा यही से होगा.
जी जी जी, no problem.
Let the child be produced.
On date of इसका एनुअल एग्जाम्स चल रहा है.
Annual exams दिसंबर में चल रहा है.
दिसंबर में चल रहा है, जनवरी में इसी.
WPC number 1709 of 2019. During the course of hearing, it appears that pursuant to orders passed by this court, the child had appeared along with the petitioners. Ordered the interview, sir. When the child had appeared.
Probably oral order होगा.
There was no
But
order.
the presence of biological mother, I think there was an order.
On 4/10/2024, the child had appeared before this court along with the petitioners in chamber. The petitioners were identified by the learned counsel by the concerned counsel of the petitioners. However, in absence of the proper identity of the lady, of the biological mother, namely Karishma Tuppo, the matter was directed to be posted on 15/10/2024. Later on, the biological mother has filed an affidavit stating that the required procedure for adoption was not followed and she is not eligible for the child being retained by the petitioners. Correct? Anybody for Jhalsa?
Because I am very for that.
What do you say?
Because I have no role in this matter. Because I was impleaded on an incorrect submission made by the petitioner that the statutory homes under the Juvenile Justice Act are managed by Jhalsa and Jhalsa can state anything about the situation of the.
But being Jhalsa, you should be in a position to assist this court regarding.
Because I can assist the court about.
You have to do that.
I do that.
Okay, you have to do the procedure. You have got the access to the entire records.
Because all of the pleadings are not served on me. Because still date, because Jhalsa was impleaded as a party. All the pleadings before that have been served to me.
You have all the copies. You provided to me, right? You have all the copies of the pleadings.
Even I don't have all the copies because I also came in between.
Yes, Mr. You have all the pleadings.
Yes.
तो आप इनसे सारा
एक नहीं है, that is filed by the
child को produce करके फिर यहाँ पर हम लोग कहाँ पर उनको रखें? Produce तो हम लोग child को कर देंगे, लेकिन कहाँ रखेंगे?
Biological mother is overwhelming your attention.
Biological mother after 15 years, कितना साल का हो गया बच्चा?
6 साल 8 महीना.
Biological mother by now has become a stranger.
But then she has been wronged, Your Lordship. That's the
15 days.
I hope you undertake to produce the child as and when you want.
As and when.
The learned counsel for the petitioners have submitted that they are ready to produce the child before this court as and when directed, and needful will be done within a period of 1 week from the date of such direction. It has also been submitted that as of now, the child is undertaking annual exam.
Exam, terminal exam. Annual.
Terminal examination. The learned counsel appearing on behalf of Jharkhand State Legal Services Authority is directed to apprise this court with regard to the procedure which was to be followed at the relevant point of time with regard to the adoption of the child. Once the biological mother is already available.
CWC can say the statutory provision.
CWC की तरफ से कौन है? CWC की तरफ से भी आप हैं? The learned counsel for आपको कुछ नहीं, आप लोग इतना insensitive क्यों?
कॉपी भी हम लोग को प्लीडिंग्स की कॉपी भी प्लीडिंग्स की कॉपी हम लोग पास नहीं
है। ये बच्चा जो है एक जगह से दूसरी जगह लटक रहा है, आप अभी खड़ा होकर प्लीडिंग मांग रहे हैं। थोड़ा तो शर्म करिए।
हम लोगों ने
Have some mercy on us.
Yes, I have filed the counter.
The learned counsel for the state is also directed to do the needful. If you are not able to do, you just let us know. We'll ask the advocate general to appear and do the needful. If you are not able to do, procedure में क्या है आपको?
I will assist as per the procedure.
ऐसे नहीं, आप written submissions file करिए। ऐसा तो इतना confusion है procedure में। From one section to another, there are rules and regulations and everything.
And even regulations are also there.
The jigsaw puzzle.
It is the councils for the state and Jhalsa should also assist this court by making specific submissions in connection with as to whether biological as to how the child born to a as to how the child born to a lady can be given in adoption. The modalities as to how it can be given in adoption.
May I make a small submission, just to assist this honorable court in this matter? There were some proceedings which were going on before the CWC. I am unable to find out the exact outcome of that
council
proceeding.
For the state is directed to produce the entire proceedings, entire records relating to the present case after obtaining it from CWC. सारा प्रोड्यूस कर दीजिएगा।
उससे सब चीज दूध पाने का पानी ठीक है।
उसी से सब चीज क्लियर हो जाएगी।
Inspection has also been done in the report. I will submit it. I have filed counter affidavit.
आप पूरा रिकॉर्ड ही प्रोड्यूस करिए, हम ही लोग इंस्पेक्शन करेंगे।
Registration has also been considered that as well.
उससे क्या लेना देना है? इम्पोर्टेंट ये है कि बच्चा किसके पास जाएगा, बायोलॉजिकल मदर के पास जाएगा कि पिटिशनर्स के पास जाएगा?
जी
ये है ना इम्पोर्टेंट। आप प्रोड्यूस कर देंगे?
Page 97 has that case number also, CWC/557.
What? Give the case number, please. Give it in writing. In relation to the following case number. तब करिएगा बताइए। How much time do you need to do this? How much time do you need to do this?
This is immediate. I have prepared something, but I will put it in a short note so that it is
section wise, provision wise, you have consultancy with the
I will have
also
consultancy with them
because they are doing it every day. Right? They are quite aware of it. You have a very good secretary. बताइए कब सुनिए?
इतना कम दिन है, हम लोग बिना चुका हमको लगा 2, 5, 7 दिन
हाँ, working days बहुत कम बचे हैं. The learned councils have submitted that the matter may be posted immediately after winter break. Post on 9th of January and supplementary. इसमें कुछ guideline करना पड़ेगा.
एग्जैक्टली सिचुएशंस बहुत फ्लूइड है, बहुत फ्लूइड है.
Especially in the functioning of CWs.
बताइए law point क्या है?
अभी देख रहे हैं हम, I have not gone through the entire file because they have also not served the copy. Even private response
law तो किताब में होता है brother.
नहीं, no private response, even private response have not served the copy.
law तो किताब में होगा.
नहीं है.
फाइल नहीं होता
हम चल रहे हैं
बिना स्टेट को सर्व किए फाइल ही नहीं होता है.
हमारे पास है फाइल हम ले लेते हैं.
अगली बार ये बहस करेंगे ना तो एडी साहब को बोलेंगे बहस करने के लिए, आपको इस केस से डिसकंटिन्यू करना है. आप लोग आपस में जितना भी है ना सारा एक्सचेंज इस तरह का सबमिशन मत करना. ये केस 2018 से चल रहा है. अरे भी आप बोलते हैं आपको फीलिंग नहीं है, आपको ये नहीं है.
काउंटर दी
पिछली बार तो नहीं बोले थे.
हमारे
एब्सेंट होंगे ना.
नहीं एसोसिएट्स आए.
एसोसिएट क्या कर रहे थे?
हम नहीं अपीयर.
बिना इंस्ट्रक्शन.
I am very frankly submitting that I did not appear on that very much.
अगली बार कोई और अपीयर होंगे.
नहीं हम
पिछला 2 बार से हम नहीं अपीयर हुए थे.
वो तो खैर कोई भी अपीयर किया तो माना जाएगा. हम कलेक्ट कर लेते हैं सब.
You do the needful.
I will do the needful.
You just jot down every date, all the sequences. और आप जो है रिकॉर्ड जो है 3 तारीख तक. The records of CDC we handed over to the learned court master on 3rd of January. ठीक है, यहाँ कोर्ट में प्रोड्यूस करेंगे, फोटोकॉपी हम रिटेन करेंगे. प्लीज सबमिट इसमें. You will have an opportunity to inspect. All the parties, you also can have an opportunity to inspect in the court. इसका list of dates बनाइए ठीक से.
I will.
Provision of law, the list of dates, the sequence in which the proceedings should have. Suppose this child was to be given in adoption. What procedure was required? This is what we want. And then we will see, you can just put it in a column. Date wise. And this is the step wise. And these are the sequences of events which were to be followed. And this particular stage has not been followed. Okay, and whether a lady, suppose the adoption was done in accordance with law, assume, can she retract from there? And at what stage can she retract? Can she say कि हमको होश नहीं था, हमको पता नहीं था, minor थे? Can she say such a statement? Because lot of emotions are involved in the child. एक केस हमको पता चला है, दिल्ली हाई कोर्ट में डिसाइड हुआ था. Perhaps advocate Aparna Bhatt was arguing that case. ये तो पता चला कि केस बहस हुआ, लेकिन अल्टीमेटली क्या हुआ हम नहीं जानते. उसमें कुछ डायरेक्शंस इशू हुआ. Find it out. Delhi was a case in Delhi.
I have another small request. My lords may consider redacting the name of the parties, lords, because this will come in public record, and this may be, lords, this may cause some problems for the child in the future.
नाम जो है ना मत उसको भी
So far as the deposit of money is concerned, there is no bank account of the Labour Commissioner Center. There are two more in bank. कोई बैंक अकाउंट में earlier it was but now it has been closed. There are two modes. It may be deposited in the Bharat Post portal, and the second is by way of demand draft in favor of the account officer, PAO, DGMS Dhamma.
यहीं से चला जाएगा पूरा पैसा. ठीक है. ये जो
It is better by way of demand draft.
Item 1 from supplementary list. WPC
आपका
4229 of 2014.
सॉरी आई एम नॉट इन प्रॉपर यूनिफॉर्म। इसमें एक चीज़ बोलना था।
भारत रीलोलिंग
हाँ, सप्लीमेंट्री वन के पिटिशनर कल मेंशन किए थे। इसमें हम लोग को जो आपने लास्ट डायरेक्शन दिया था,
ये तो आपने दे दिया है कि नहीं है आप
नहीं है। हाँ, तो
तो
इसको
वो छोटा सा मैटर है, क्यों पेंडिंग?
इसको कल रख दीजिए, कल रख दीजिए सर। मैं फाइनली डिस्पोज ऑफ
बहुत ही छोटा सा मैटर
जी। पिटिशनर चले गए, वो मैटर चलना शुरू हुआ तो लगा कि जैसे नहीं होगा।
बहुत छोटा सा मैटर है, इसमें कुछ नहीं करना।
इसमें कुछ बचा भी नहीं, मतलब गिरबान उनका भी रेस हो गया, इन लोग भी अपनी तरफ से बोल ही दिए, हम लोग का कोई रोल है नहीं।
और उन्होंने जो अपने रिप्लाई में लिखा था कि अंडर द वर्बल इंस्ट्रक्शन ऐसा हुआ था, उसको उन्होंने कभी रिफ्यूट भी नहीं किया इन द एंटायर रिकॉर्ड। उसके बाद जो उसका जवाब आया है उसमें भी कभी रिफ्यूट नहीं किया।
यस,
सो दैट स्टैंड्स एडमिटेड। एक सिमिलर ऑर्डर ऑलरेडी हो चुका है, तो नाउ द एंटायर प्रॉपर्टी इज अवेलेबल फॉर यूज। ठीक है, कर एक आपका मैटर है ना मिस्टर रूल्स, कहाँ है रिस्पोंडेंट? या नेसेसरी एक केस
Item 6 WPL 3826 of 2024.
not that 25 है। Not the main intent and object of 25 was to overcome the workman from sudden termination.
तब तो यार जितना भी रेगुलराइजेशन का केसेस यहाँ होता है सब तो लेबर को
Not 25 says that prior notice has to be sought before retrenchment or any termination of service, because if the workman
No, I just they are on the point of jurisdiction. That the labor court did not have the necessary jurisdiction to decide this case. They are on the point of jurisdiction that the labor court did not have the necessary jurisdiction because it is a department of the state government.
But they are saying that the water resources department is not an industry to be covered under IDA.
Yes, that is their case.
That is their case, my lord. If at all, my lord, it may be presumed that it is not an industry, my lord. Even though, my lord, if any employee is retrenched or terminated, my lord, prior notice has
The
to.
labor code will not cover.
That issue, my lord, has to be.
F also will not come into play.
If, my lord, that is not.
Industrial Disputes Act will not operate for such a case.
Yes, my lord. But if it is an industry, my lord, that will come under Industrial Dispute Act. If it is not, then 25 is no applicability. I am saying that, my lord, it is an industry under, my lord, Industrial Dispute Act to be sent notice under 25. There is a dispute between, my lord, workman and the employer regarding retrenchment. So 25F, and, my lord, the compensation is very meager amount, my lord, 25,000, which was ordered to be paid, my lord, to the workman. So they are, on the one hand, my lord, they are not complying the 25F, my lord. Other hand, they are not paying the.
Normal government service को 25F के बाद determination होता है.
May I be permitted to refer clause 2A subclause 2 of the IDA. Yes, ma'am. 2 small a. 2 small a is appropriate government. Clause A and clause 2, my lord, I am reading.
2A. Clause 2.
2A, Roman small 2. May I read? Yes. In relation to any other industrial dispute, including the state public sector undertaking, subsidiary companies set up by the principal undertaking and autonomous bodies owned or controlled by the state government. So, my lord, department is under the state government. That is controlled by the state government. So any dispute arising out of that department, my lord, which is controlled by the state government, will be a dispute under Industrial Dispute Act. industrial dispute says that dispute between employers, workmen. So my lord, there is a dispute between employers and workmen, and it is a department governed by the state government. So that is also a dispute to be considered under IDF. So my lord, if it is a dispute to be considered under Industrial Dispute Act, my lord, 25F has the applicability. And the very purpose of 25F is to issue a prior notice and my lord, the compensation for 15 days. So 25,000 was ordered to be paid, my lord, in compliance of 25.
And autonomous body is owned or controlled by the state government.
Yes, ma'am.
You see, it is for the, it is
Provided that
2A is the definition as to who would be the appropriate
Appropriate
authority for refer the dispute, to refer the dispute.
yes, madam.
This is not a provision as to whether the state government itself will be an industry.
That no matter that is the meaning of appropriate government.
That's right. So people will go before the appropriate government and appropriate government will make a reference.
Yes.
If it is arising out of a reference,
Reference is not.
it is not arising out
No,
of a
it is filed under section
It has been directly filed under section 2.
Yes, ma'am.
For
regularization.
So there is no reference by the state government. Right?
My lord, I am just showing that it has written that any industrial dispute, including the department owned by the state government. So the water resources department is a department owned by state government, and dispute is arising in that department. So that is in relation.
The state public sector undertaking.
Yes, ma'am. In
Subsidiary
relation to.
company, just a moment.
Yes, sorry.
Including the state public sector undertaking, subsidiary companies set up by the principal undertaking, and autonomous body owned or controlled by the state government.
Yes.
So therefore, if there is an autonomous body of the state government, if there is a public sector undertaking owned by the state government, right? Therefore, under such circumstances, the dispute will be referred by the state government to the appropriate authority. Like HSC का dispute जाता है
Any
industrial
autonomous body
dispute,
controlled by state government.
right? Therefore, if there is an industrial undertaking or an establishment set up by the state government, then the application has to go to the state government for the purposes of making reference. But if the employee himself is a direct employee of the state government, then under such circumstances,
My lord, they were contractual employees. The crux of, my lord, the main objective of this section, I am showing that if at all it is referred by the state government, what is the objective, my lord? To show that there is a dispute arising in their department. If, my lord, if at all it is referred by the state government, if at all referred, my lord, but the main crux, the main objective, why it is to be referred to cope up with the dispute, my lord. So I am just showing that there is a dispute arising in the department owned by the state government. Although my lord, it is not referred, but if at all it was referred, it would have been referred, my lord. The main crux, the main objective is to cope up with the dispute, to redress the dispute. And
now tell us, there is a finding that the unit was itself closed after 31/3/2009.
yes, on that point, my lord, the learned labour court has held that although the 9 years have been lapsed, so the prayer for regularization was not considered. If similarly situated person are given the benefit of regularization, that will be seen by the management, my lord. But so far as
what kind of regularization? When the unit is closed, they will regularize you on the again.
That-
What?
my lord, the workman was not regularized.
Therefore, when you see, you have worked till 31/3/2009,
Yes, my lord.
right?
Yes, my lord.
And there is a finding that from 1st of April 2009, the unit was closed.
Yes, my lord.
कहाँ पे regularize किया?
But my lord, so far as regularization is concerned, my lord, that the workman was not regularized, but the amount of compensation of 25,000 was directed to be paid to the workman. They are also not complying.
In a case where the unit is closed,
My lord, the unit is closed,
still
work is over.
25F is to be satisfied.
My lord, in case of retrenchment, my lord, the main purpose was to, my lord, retrench इसलिए किए हैं कि काम खत्म हो गया हो, इसलिए छटनी कर दी, रिट्रेंच कर दी, काम ही नहीं है तो नहीं करवा रहे, बट छटनी तभी, रिट्रेंचमेंट तभी होगा व्हेन the work is on the fag end, my lord, and other workers are not required, with some 2 or 3 workers can be come to an end, my lord. So retrenchment was done, but they must be served with the notice that their services are going to be retrenched. Now, my lord, I may be permitted to read para 18, page 18 of the judgment, my lord, the issue number 3. What relief or reliefs the petitioners are entitled to?
Which page number?
Page number 18 of the running page number 18 of the judgment, my lord, page number 34 of the plea. Para 15, issue number 3. Issue number 3. What relief or relief the petitioners are entitled to? It has already been found and held that the workmen failed to prove that they worked even after 31/3/2009 with the management. It has also been held that provision under section 25A of the ID Act was not complied with by the management in engaging the services of the workmen after 31/3/2009. So, although the workmen are not entitled to due wage after 31/3/2009 as claimed by them, but some compensation must be granted to them for removing them from their duties without following the due procedure and without notice. The present case has been filed by the workmen in this court on 28/2018, that is after more than 9 years from 31/3/2009, which is inordinate delay in filing this case. However, in the fact and circumstances of this case, in my considered opinion, a sum of 25,000 may be adequate compensation to the workmen. It has been contended by the learned counsel for the workmen that similarly situated persons have been given the benefit of regulation. The learned AGP did not deny the services of some similarly situated persons have been regularized. So the workmen of this case are at least entitled for consideration of their cases for the regulation of their services. In the light of the above discussion, order is passed that the workmen are not entitled to the wages after 31/3/2009, but they are entitled for compensation to the tune of ₹25,000 each for removing them without notice and following due procedure under section 25 of the IDA. The management is directed to pay the said amount within 19 days. Madam, I'm just showing that although they yes, the management,
Although the workmen cannot claim for.
Although the workmen cannot claim for regularization of their services as a matter of right, but their claim is required to be considered by the management if cases of similarly situated persons have been considered and their services have been regularized. All such exercise should be done by the management at an earlier. So, my lord, although their case for regularization was not considered, but a direction was given that if similarly situated person was regularized, then their case may also be considered in aspect of regularization. They are saying that I am not claiming for the wages of after 31/3/2009 because my lord, on 1st April 2009 the project is closed, my lord. So no claim for wages, no claim for regularization, my lord, existing. Only I am on the point, my lord, that meager amount of 25,000. That even that is not being complied by the management.
You are only concerned with 25,000 rupees.
Because my lord, so far as
And what about the regularization?
My lord, so far as regularization is concerned, it is stated that if cases of similarly situated person have been regularized, then and the petitioner is also found to be similarly situated, their cases will also be considered.
So you are asking for your job back.
If my lord, similarly situated persons have been considered, then my lord, in the case of equality, the workman, present workman will also be considered for regularization. And my lord, in the first page of judgment,
Where is the finding that you have completed? What is the period? When was the dispute raised?
2018, my lord.
2018. When did you raise the demand?
2009. Sorry. 2018, my lord.
When were you discontinued?
2009. Yes. So for 9 years, my lord, inordinate delay.
No. Is there any finding that you have worked for 240 days in the previous calendar year? Because you are a daily wager.
Yes, ma'am.
Is there any finding that you have worked for 240 days in the previous calendar year? As per the requirement under section 25(b).
Yes, ma'am. Yes, ma'am. My lord, the wages were paid up to August 2006, and they were, my lord, came to service in the year 1976 for construction of barrage.
You see, the length of work is not important. 240
Continuous.
days in, not continuously, 240 days
In the last
in
1 year.
12 years, 12 months.
1 year.
Is there any finding to that effect?
Three issues are dealt regarding 240 days, my lord, the issue is not that.
Issue is not fixed. That is a condition precedent.
But my lord, in para 3 of the judgment, my lord, the management is saying that the engagement of workmen were terminated after duly complying with the provision of 25. So, my lord, how can they claim, my lord, that they have complied the provision of 25? They have never complied.
Because they have claimed, therefore this is understood that they have not complied with the provisions of. So
And
therefore the court has examined whether the 25 provision was complied with.
that has not been complied.
One of the things which I was repeat, I just want to repeat one that this application was filed under section 2 capital A subclause 2, my lord. And in that as per that section, my lord, the petitioners has to go, this body has to first go for the translation, and thereafter the translation officer will send the matter to the labor court. This process has not been followed in this matter, first of all. Second, my lord, that section 225F is not applicable in this case, in this case, as the department is an industry, is not an industry under section 2J of the Industrial Disputes Act, which I have, for that I have also mentioned the judgment of this honorable court also, that this department is not considered as an industry.
वो judgments का reference है,
My lord.
उसमें तो अलग से order drop
My lord.
करना पड़ेगा। Okay, WPA number 3826 of 2022 for the learned council on behalf of the parties, the learned council of the petitioner has submitted that the water resources department of the state of Jharkhand is not an industry, and therefore the learned labor court did not have the required jurisdiction to entertain the case filed by the concerned workman directly before the learned labor court under section 2A, 2 of the Industrial Disputes Act. He has relied upon the judgment reported in 2006 1 DCR 58 within bracket state of Jharkhand versus Lala Rao and also judgment passed by this court in reported in 2014 SCC on 9 JR 2907 within bracket Pranay Kumar Srivastava versus state of Jharkhand. The learned council submits that the learned labor erred in law in entertaining the petition, and therefore the interim award has been passed by wrong assumption of jurisdiction. He has further submitted that the condition precedent for filing an application under section 2A within bracket 2 of Industrial Disputes Act has also not been followed in as much as the respondent never approached the conciliation officer. The learned council has also submitted that a finding has been recorded that the workmen were not continuing with their services under the petitioners since 1/4/2009, and they have received their remuneration till 31/3/2009. He has also submitted that the learned court has recorded that the claim was a stale claim as the dispute was raised after more than 9 years, but still granted certain relief to the concerned workmen by directing for payment of compensation to the tune of rupees 25,000 per head.
Per head.
25,000 per head, and also granting the relief of regularization. Regularization, The learned counsel appearing on behalf of the respondent has opposed the prayer and he has relied upon the provision of section 2 within bracket
Small a,
small a
Roman small 2.
Roman small 2 and has submitted that the case was maintainable before the learned labor court. He has also submitted that there is no illegality or perversity in the implement award calling for any interference. Only a small amount of ₹25,000 has been directed to be paid as compensation on account of not following the required procedure under section 25 capital F of Industrial Disputes Act. Upon inquiry by this court regarding the condition precedent for payment under section 25 capital F, the learned counsel submits that it was a specific case of the petitioner before the concerned court that required provision or that the provision of section 25 capital F of the Industrial Disputes Act was duly followed. He has also submitted that the improved award does not call for any interference. That's it. Go ahead. कोई दिन रखिए so that
डेट और
बाकी दोनों डेट में भी
डेट
वो मैं इसका रिकॉर्ड भी उसी के साथ रिकॉर्ड में सबमिट किया ना दो केस
Yes,
किए
ma'am.
दो क्या नंबर है उसका
The day before yesterday it was listed, so I'm providing the number.
CABS को भी CAB करके उसी के साथ एक ही साथ Here also you did not take the point regarding whether the state is in industry or not.
Yes, ma'am. Yeah, I've taken that.
You have taken that
Yes,
point?
I've taken that point.
That point has been decided against you?
No, Lord, in the before the labor court, Lord. No, before the labor court, I believe. Yeah.
The learned counsel for the petitioner has submitted that though before the learned labor court, the petitioner did not take the plea that the petitioner is not an industry within the meaning of Industrial Disputes Act, but the same being a point of law can be considered by this court, particularly when in view of the aforesaid two judgments.
No. Malad, that is WPN 1530 of 2024, Malad.
1530
2024, and another is 1544 of 2024, WPN.
2024.
2024. 1544 of 2024. So the object was regarding that the response says that it's a meager amount of 25,000 for each person. For that, it says that 25,000. It's not. It is a public money first of all. Second thing is that it will become the floodgate for the various other persons. It is now only for the 4 person as club. Now again.
ना आपके quantum से हमको मतलब है, ना आपके floodgates से. We have to decide every case on its own facts. वहाँ पे इतना floodgate का चिंता थी तो वहाँ क्या कर रहे थे? वहाँ नहीं होश आया. It's not an industry. What were you doing over there?